Florida is on the verge of becoming the 26th state in America to have permitless carry, which some of you call constitutional carry. I've got some observations that might be interesting to people who are down there in the state of Florida. Stay tuned. I'll walk you through my thoughts. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times bestselling author. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so. We're trying to get to 100,000 subscribers to help with the social media algorithm. All right, so we have good news in Florida as I see it. We've talked about this for some time. The state of Florida seems to be moving toward enacting some form of permitless carry or constitutional carry regime to replace its current sort of shall issue permanent regime when it comes to carrying guns outside the home in the Sunshine State. So that is overall very, very good news. But because the sausage, if you will, is being made down in the state of Florida, I wanted to make a few observations that I thought might be interesting to the people in the Sunshine State when it comes to these issues. In no particular order, number one is I do think that Governor Ron DeSantis has no choice, and I think he supports this completely, by the way, but he has to make sure that a permitless carry regime gets enacted in Florida, because his potential presidential opponent for 2024, Greg Abbott, the governor of Texas, among others, has made sure that in their respective states you have permitless carry. So now that Ron DeSantis has what appears to be solid Republican majorities all over the state of Florida, thank God, he has to make sure that he delivers on that permitless carry promise, which I suspect he's going to do so. So that's very good news. But it has to be done if he has any chance to be the nominee for the Republicans in 2024. That's the first point. The second point is, and I want to put these into three separate buckets. There's the A bucket, which I think is very important. There's the B bucket, which I think is important to understand. And the C bucket, which I'm going to say is kind of a stretch. But I want to talk about the A, the B, and the C buckets. So in the A bucket of what I consider it has to have in the permitless carry law that gets enacted by Florida, I think there's two things, in addition to the obvious things that other people have talked about that allows you to do this, permitless carry in the state of Florida. But more specifically, I think there's an opportunity to enact this, and I think there is. Number one is it has to make sure that non-Floridians will be able to benefit from it. So if somebody from Ohio goes down to Florida and is able to carry a gun in the permitless regime, in other words, we want to make sure that the permitless regime applies not just to Floridians, but also to all Americans in that state. So that's very important. You don't want to look like you're discriminating against non-Floridians if you're a future presidential candidate. And you don't want to do that anyway, because as you know, the Second Amendment's right to keep and bear arms applies to all Americans, not just Floridians, but all Americans, as far as I'm concerned, wherever you are, just like the rest of the Bill of Rights. Like if I live in Vermont and I fly to California or to Maine or whatever, my other constitutional rights travel with me. I can go to church in California, Vermont, Maine, Texas, it doesn't matter. I also have the right to free speech in those places. One wonders why your Second Amendment rights would be left behind just because you leave a particular state to go somewhere else. It shouldn't. So Florida should recognize that and make sure that everyone in the country that's law-abiding and complies with the law, and to make sure that they are able to carry in Florida concealed. Next thing, of course, is I think there's some key language that I would add, because remember, not only do you have the operative law, but there's also the opportunity for the state of Florida's legislature to enact the law with like a preamble or summary, whereas clauses, whatever you want to call it, as to why they're enacting the law. And some of the language I think they're going to want to include is things that could be used by other states and other organizations and other things in court or beyond. So why not create a favorable record, a legislative record that can be used by courts and others, maybe even other states, maybe even Congress down the road, to be able to cite to? Because as I've always taught you, when it comes to any constitutional part of the law, including the right to keep and bear arms, every favorable fact, every favorable law, every favorable statute, every favorable regulation, every favorable court ruling is another brick in the wall that we want to use to put together to build a wall to protect our Second Amendment rights. So to the extent that you can enact legislation in Florida for permitless carry that has multiple bricks for that wall to protect our rights, that is a good thing. And as many bricks that you can reasonably put on there to help build that Second Amendment protective wall, the better it is for all rights in America, especially those including the right to keep and bear arms. So some of the language I might include if I were drafting the statute which of course I'm not. I don't even know who's working on this, so I don't talk to anyone in Florida or anything like that. So again, my thoughts are sort of semi-speculative, just kind of general observations. I don't have any specific inside knowledge of where this is going. I think it's in committee and it's going around the committees. There are people in Florida that I'm sure know a lot more than I do about this. But this is the sort of language I'd be looking to add if I were down in Florida. Some of the language I would include would be number one, I would say, whereas the Second Amendment states that the right of the people to keep and bear arms shall not be infringed, and the Florida Constitution also protects this basic fundamental human and constitutional right. I would make an observation about that. Whereas I would also say, whereas the constitutional right has been held to be fundamental by the U.S. Supreme Court, and the Supreme Court has held that the Second Amendment's protection of it constitutes a, quote, unqualified command, close quote. That's Supreme Court language, unqualified command and fundamental. Both, I think, would be mentioned in the preamble. That's how I would draft that statute. I would then also make an observation, whereas half of the states now allow the carrying of handguns by law-abiding citizens without any sort of license or permit. I would then also add, and remember, this is something we've talked about before on this channel, that there's technically a distinction between permitless carry and constitutional carry. In many respects, the words permitless carry is more accurate and better for the movement than constitutional carry, and it's because permitless carry implies and makes clear that our right to keep and bear arms does not come from the Constitution. It is a pre-existing right that the Constitution, Second Amendment, Constitution and the Second Amendment codifies and protects, yes, but the right itself, the substance of the right to keep and bear arms, is actually pre-existing. So to me, in some ways, I think the words permitless carry is better for the home team than constitutional carry, which suggests that my right to carry is the Second Amendment. Technically speaking, your right to carry is a pre-existing right. It's the Second Amendment just simply codifies that pre-existing right. So I would make a reference to that in a preamble, that this is a pre-existing right that even goes back before the existence of the 1791 Second Amendment. I might even make an observation that the right to self-defense goes all the way back to the beginning of time. It is a right that extends long before, I would argue, before the Constitution or any of these sorts of things. And I'm going to give you some language actually from a court case in a second. I would also make an observation that no other fundamental right, First Amendment, Fourth Amendment, any of these other things, none of these other fundamental rights that we have as Americans require you to go, mother may I, and ask permission of a government for a license to engage in the activity. We certainly don't need a license from the government to post things on Twitter. We certainly don't need a license from the government to do YouTube videos or to go out on the street corner and talk about politicians or policies or politics or poetry or whatever. So why do we need any kind of a license to exercise the right to keep and bear arms? I know there's some dicta in the Bruin decision about that. As to whether or not what that means down the road, we don't know, other than I think the Supreme Court was kind of signaling that they don't want to deal with, facial challenges to carriage laws right now. There's other bigger fish to fry, and I would agree with them at that point because, again, as you know, the law works incrementally, and incrementalism is a critical thing we must understand in the Second Amendment movement, that we want to take one step at a time and continue to expand on our existing freedoms. And what we're really doing, of course, is we're not expanding on our freedoms. In some ways, we're restoring our freedoms to a place where they never should have left, because over the last 50, 60 years, we've had this liberal encroachment, progressive encroachment on our right to keep and bear arms brought to us, not just by liberals and progressives, by certain law and order conservatives, at least in the 80s and the 90s, that were not favorable to the right to keep and bear arms as it applied to civilians. But anyway, we are slowly but surely restoring our right to where it never should have left, and we are restoring our right to, I think, where the Founding Fathers viewed it at the time of the Second Amendment of 1791. With that said, I would also segue and make reference in the preamble to two quotes. I would specifically mention Chief Justice Joseph Story, a famous Supreme Court justice. He was, I think, the youngest Supreme Court justice in American history. He was appointed to the bench, I believe, thanks to James Madison. And this is something that, and Joseph Story is cited, I think, more than anybody else in the history of Supreme Court jurisprudence, I believe. He's a very well-known commentator. The Supreme Court has talked about him for literally centuries as an important authority on the meaning of the Constitution. And this is what former Supreme Court justice, who was Supreme Court justice in the early 19th century, said. This is what Joseph Story wrote about the Second Amendment. He wrote, quote, "The right of the citizens to keep and bear arms has justly been considered as the palladium of the liberties of a republic." That's a big statement. That's the essence of protecting the liberties of Americans, is what Supreme Court Justice Joseph Story said. I should let you know that Joseph Story is an extremely important judge. You've heard about him before because he was one of the stars in the Steven Spielberg movie, The Amistad, which of course was the ship that slaves conquered and took over at sea. And it was Joseph Story, as the Chief Justice of the United States, that said and wrote the opinion that said the slaves on the Amistad were free people and could not be brought back into slavery. That's the same Joseph Story that has this quote, the right of the citizens to keep and bear arms has justly been considered as the palladium of the liberties of a republic. Again, Joseph Story, a huge deal in early America, and the author of the Amistad decision, which you probably saw on the big screen when you saw the movie Amistad by Steven Spielberg. Beyond that, I would also quote James Madison down there in a Florida preamble, if that was going to be written, that says something like that America, unlike in certain despotic states, unlike those despotic states, we are, quote, not afraid to trust the people with arms. That's right. Madison said that we are, quote, not afraid to trust the people with arms. I think that's a great quote from James Madison, that part of being a citizen is the right to property, the right to vote, and of course, the right to keep and bear arms and protect yourself. That goes all the way back to Greco-Roman times. And the last thing I would just say, I would add something that says there's simply no reason to think that a permitting scheme is necessary for people to be able to exercise their fundamental constitutional rights, which the Second Amendment right to keep and bear arms clearly is, for many reasons, not least of which is the decisions of Heller, Caetano, McDonald, and of course, most recently, Nyserba versus Bruin by the U.S. Supreme Court. So those are what I consider the A-list items. There's a B-list item here, which I know there's a debate about whether or not to have open carry or concealed carry in Florida. I know right now it's concealed carry, and open carry of firearms is banned. I'm not going to weigh in on that debate because there are people in Florida that are much more familiar with kind of the dynamic of what's going on there. I certainly have no problem with open carry. I have no problem with concealed carry. I'm perfectly fine having both. I think you should have both. With that said, I know there's probably dynamics in Florida about the pros and the cons of that. I do want to flag one thing because I think this is an important teaching moment. Historically, the American courts, including I think the Supreme Court itself, basically has a vision. I'm not saying they've articulated it clearly, but basically I think that their understanding of the Second Amendment would be consistent with a case that you may never have heard about, and I'm going to link to down below. It's important that you know this case. It's a case called Nunn. That's N-U-N-N, Nunn versus the state of Georgia. It's from the year 1846. That's right, 1846, Nunn versus Georgia. This is actually after the founding period, but I think it's kind of telling about sort of the early American understanding of the Second Amendment. And the reason why this is important is it was a criminal case where a person was arrested in violation of allegedly carrying guns. And basically this is what the Supreme Court of Georgia said. The Supreme Court of Georgia dismissed the indictment and says that while the state of Georgia may legally ban one from concealed carrying a gun, if they do that, they cannot also ban you from open carry, because down in Georgia, people would open carry and they tried to ban concealed carry, and there was some suggestion that you couldn't open or concealed carry, and the Georgia Supreme Court came out and says, sorry, that violates the right to keep and bear arms. You have to allow people either to conceal carry or to open carry, is generally speaking how the Nunn versus Georgia case was interpreted, but there's some fantastic language here. Here is what the Supreme Court of Georgia said in Nunn versus the state in 1846. Powerful quote. It's a long quote, but very powerful, and I'll put a link to it down below so you can check it out yourself if you want. Quote, the right of the people to bear arms shall not be infringed. The right of the whole people, old and young, men, women, and boys, and not militia only, to keep and bear arms of every description, and not such merely as are used by the militia, shall not be infringed, curtailed, or broken in upon in the smallest degree. And all this for the important end to be attained, that being the rearing up and qualifying a well-regulated militia so vitally necessary to the security of a free state. Our opinion is that in any law, state or federal, is repugnant to the Constitution and void, which contravenes this right originally belonging to our forefathers, trampled under the foot by Charles I and his two wicked sons and successors, reestablished by the Revolution of 1688. That's the English Bill of Rights we've talked about before. Conveyed in this land of liberty by the colonists, and finally incorporated conspicuously in our own Magna Carta, which they're referring to the Bill of Rights in the Second Amendment, and Lexington, Concord, Camden, River Raisin, Sandusky, and the Laurel Crown Field of New Orleans pled eloquently for this interpretation. And the acquisition of Texas may be considered the full fruits of this great constitutional right. That is very eloquent and powerful language about the right to keep and bear arms from 1846, the Georgia Supreme Court. So, as applied to that notion, here is what the Georgia Supreme Court said about the specific case presented about whether or not a ban on carrying arms is constitutional. It says it is not. Here's what they write. Quote, "We are of the opinion then that so far as the Act of 1837, which is the Georgia statute they're interpreting, so far as the Act of 1837 seeks to suppress the practice of carrying certain weapons secretly, that it is valid inasmuch as it does not deprive the citizen of his natural right of self-defense or of his constitutional right to keep and bear arms, but that so much of it as contains a prohibition against bearing arms openly is in conflict with the Constitution and void. And that as the defendant has been indicted and convicted for carrying a pistol without charging that it was done in a concealed manner under the portion of the statute which entirely forbids it, the judgment of the court below must be reversed and the proceeding quashed." So the bottom line is that the Supreme Court of Georgia said in Nunn versus Georgia that Georgia had to permit carriage, had to allow carrying guns, whether open or concealed. They could ban concealed carry, provided that they allowed open carry. And I think that most judges in America, in interpreting the Second Amendment, I would say, generally speaking, say that as long as you allow one method of carrying a gun, either open or concealed, then that satisfies the Second Amendment and the right to keep and bear arms. So just kind of keep that in the back of your mind. And a very important case, I think, in the judicial thinking in modern America is this 1846 decision of Nunn versus the state. The last observation I want to make is just really quick. This is what I call the C bucket, the last bucket, which is more of a stretch bucket. It's an observation I'll make for people to start to reflect upon. I haven't fleshed this all the way out, but under federal law, you have a statute called LEOSA, which is the Law Enforcement Officers Security Act, that allows any employee, there's a specific statutory requirements. I won't go through all the details here, but the bottom line is that if you are employed as a law enforcement officer anywhere in America, you can conceal carry nationwide under the federal statute of LEOSA. Now, there's very specific elements that have to be met. You have to have the right to arrest, the right to carry as part of your job, and so on and so on. You have to be an employee of a law enforcement agency. So the way I would be thinking about it is anyone under the state of Florida that could actually qualify for LEOSA, and perhaps the state of Florida could look to people in civil defense or other categories besides full-time police officers or state police or sheriff's offices. You know, one wonders whether or not there's a way under Florida law to expand the scope and the number of people that are employed by the state of Florida or within Florida, it could be a local agency, so that more and more Floridians could qualify to conceal carry nationwide under the federal statute of LEOSA. Again, of course, to, expand the scope of people eligible under LEOSA under a state or local law would require, some thought and strategy, more than I'm going to get into on this video. But I do want to flag that as Florida is considering expanding or restoring the right to carry to more and more Floridians in various ways under their new statute, they may want to reflect on whether or not there may be some additional categories of Floridians that are working down there or are tied into the civil defense or the law enforcement community or the penal system, whatever, whether or not there are some other ways to expand the number of people that qualify for nationwide concealed carry under LEOSA, because certainly to the extent that the Florida legislature can help Floridians carry nationwide, that is certainly something I would say the Florida legislature should be interested in doing. Whether or not it's practical right now in this session, probably not, but it's certainly something that someone can put on the back burner and begin to reflect upon as they move forward down there in the state of Florida, since they're contemplating changing some of their gun laws. All right, folks, I hope you learned a little bit something here about some of the observations I have from afar about what's going on down in Florida and their potential permitless carry regime that they're looking to implement. If you haven't subscribed to the Four Boxes Diner, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.